The lawyers for two Aboriginal men accused of a black-on-white killing are challenging the way juries are chosen in the Northern Territory. They say the selection process in Central Australia knocks out so many Aboriginal people that the jury doesn't represent the community, so people can't get a fair trial. They claim the Northern Territory Juries Act is inconsistent with the Racial Discrimination Act and even the Constitution.
The two men charged with murdering Ed Hargraves face life sentences if convicted. He was well known and well liked. Lawyers for his accused killers say they can't get a fair trial because of the way juries are selected. They've told the Supreme Court the whole process is hopelessly skewed. Almost half the population of Central Australia is Aboriginal, and juries are supposed to represent the community. But in Alice Springs, the proportion of Aboriginal people on juries is significantly lower than in the town's population. More than 80% of the Territory's prison population is Indigenous, and the lawyers say that's part of the problem. The Juries Act requires people who've been sentenced to imprisonment in the past 7 years to be excluded. And in the Hargraves case, that rule saw a quarter of the potential jury pool knocked out. The lawyers say a grossly disproportionate number of them would have been Indigenous. They say even more Aboriginal people get excluded because potential jurors are sent letters in the mail. But Australia Post doesn't deliver to Aboriginal town camps, and little of the mail sent to the council is picked up. The submissions argue the failures are fundamental, and the effect is that the accused are denied a fair trial. Lawyers for the accused men say this case deserves special vigilance because the accused are Aboriginal and are facing a murder charge involving interracial issues. It'll be up to 3 Supreme Court judges to decide if the arguments are valid. The murder trial is on hold until the issues are decided. Katrina Bolton, ABC News.